I'm Roisin O'Dooley. I'm a solicitor at Roydsworthy King in Bath, and I'm here on behalf of Bristol Law Society. Bristol Law Society look to put together a number of PI and ClinNeg talks each year, and to make sure that we're targeting the interests of our members. And as I said, this is one of the topics that came up as something we really wanted a bit more input on. So we're very thankful to Nicholas and Lois for coming today to talk to us about this topic. And without further ado, I'd like to hand over to Nicholas.
Okay, well, thank you very much, Lucy, and thank you to everyone who's joined but who I can't see. As no doubt you know, my name's Nick Ferrari, and I'm presenting today with Lois. Lois is a PI practitioner with I think a healthy mix of claimant and defendant work, based at No. 5's Birmingham office. And I am based in the London office, and I began my life at the bar doing a mix of employment, commercial and PI. But for the last 10 or so years, I've been doing exclusively PI. Now the scheme of this talk is as follows. Lois is going to begin with some discussion and I think worked examples of essentially how things have changed with the advent of Swift and Carpenter. I will then move on to address in the main the circumstances in which it might be or probably is the case that the methodology in Swift and Carpenter will not be applicable. And I'll then hand back to Lois, who's going to finish with some discussion of child claimants. In terms of the slides, I'm told that they are available from the Bristol Law Society and that they will be sent out to you all in due course. If I'm wrong about that, then they'll certainly be available from No. 5, and you can contact us directly if you want them. And I'll probably just pay tribute at this point to Lois for her hard work in doing the slides. I'm afraid to say that I can't claim credit for them. I think the last thing by way of introduction is on questions. I think there's a question and answer function. We're going to try to allow time at the end of the talk for questions. So if there's time, we'll come to any questions that are sent to us at the very end. But if time doesn't permit, then I'm sure I speak for both myself and Lois when I say that you are of course welcome to contact us directly. I think you should have our details. If you don't have our contact details, then they're easily obtainable by a quick Google search. I'll just say this about a Google search. I do not moonlight as a controversial DJ for LBC radio, so you can disregard any hits that you get to that effect. It's No. 5 Chambers that you're after. With that being said, I think I can pass on to Lois.
Perfect. Yeah, I think hopefully our email addresses should be on the final slide as well, both mine and Nick's. So if you do have any questions that we don't get round to, we'll come on to those. And similarly, I think we had one question submitted before the talk today. Ideally, I'll deal with that at the end as well. Hopefully you should now be able to see my screen. I think it's worth starting with the status quo as it was. So looking briefly at the case of R versus J, and why Robertson Johnston stopped being applicable once we had a negative discount rate. I'm a fan of working examples, so apologies, but throughout you're going to get a working example of pretty much anything I say because it's the way I work through things best. So we can see the problem straight away. If one takes a fictional claimant who's 35 at the date of trial, we assume she has normal life expectancy. And to take a very basic example, ignoring adaptations or betterment or anything like that, one can see that if we run with a pre-injury accommodation of £200,000, a post-injury accommodation of £300,000, if we run it on the old discount rate, so 2.5%, straight away we can see the difference in multipliers between a positive and a negative discount rate. But if we were to run it on 2.5%, then the accommodation claim would amount to positive £72,425. If we run it on a negative discount rate, so minus 0.25, then we can see straight away that the award becomes minus £14,202.50. And I think it's fair to say that the accommodation formula that was before Swift and Carpenter, there were a number of complaints about it. Not everybody liked it, but in essence, it rumbled on and everyone got on with it. What then, of course, happened is once we've got a minus 0.25 discount rate, you've either got a negative accommodation figure or indeed it'll just be made as a nil accommodation figure. And that's what led to Swift versus Carpenter. The claimant, Charlotte Swift, suffered serious lower limb injuries in a road traffic accident, which resulted in a below-the-knee amputation. And the property she required as a result of that was £900,000 more than the value of her pre-accident property. And clearly, as we can see, if one does an R versus J formula, there would be a nil award for accommodation. And indeed, when this came before the courts at first instance, the court were of course alive to the difficulties of this. But Mrs. Justice Lambert felt bound by R versus J and made no award for accommodation. Nick's going to look in more detail than myself at the appeal, but in essence, the appeal suggested several alternatives, but the result was that reversionary interest at a rate of 5% per annum was found to be the best solution at that time. Reversionary interest, when I first started to try and read about it before Swift, to try and get a feel, because there was a feeling this would be one of the options, can become unnecessarily complicated. And again, back to my favourite theme of a working example. The way I found it most simple to understand is, in effect, if we have a scenario where I am the life tenant of a property, so I am entitled to reside there for as long as I live. If Nick holds all of the reversionary interest in that property, then once I die, the property and title reverts back to Nick and not to my estate. And for anyone who's watched the hearing in its entirety on YouTube, in that example, Nick is the remainder man, in effect. And so hopefully now that is how it was premised. And the decision in Swift versus Carpenter is that one values the reversionary interest, and then that is deducted from the difference between the pre and post accident properties, and that gives you your figure for damages. And if one looks at the screen now, you should hopefully be able to see a working calculation for this. So we have here that the interest rate is 1.05. It's always the same in the formula because the court decided 5% per annum. Life expectancy here of 52.94. New property cost of 300,000. But for property cost of 200,000. And that life expectancy is just a crude standard one using table 2 at 0%. And below is the formula. And I must say, I'm reliant on Excel spreadsheets often, but this is a formula actually that is incredibly simple to do. And I'm told, I don't have an iPhone, but I'm told you can very easily do it on an iPhone. You can certainly very easily do it on a calculator. The only expert evidence that's really needed is the cost of the new property. And then you're doing 1.05 to the power of minus life expectancy times by the new property cost minus the but-for property cost. And that gives you there the reversionary interest. So if one does it on the example on screen, your reversionary interest comes to about £7,555.07. And then we can see the damages calculation for that head of loss below. So you've got 100,000 minus that reversionary interest. And that gives you the figure for accommodation. Now, it's worth saying that is a very simplistic example, and we're going to be dealing with adaptations. Nick's going to be looking at why this doesn't really work in short life expectancy, and also we'll be looking at child claimants. But hopefully that just gives you a working example idea of how this formula works in practice. Now, coming on to adaptations and betterment. This is something that when I was reading through the judgment immediately after, it's not explicitly addressed in Swift versus Carpenter, but perhaps that's because it's not overly controversial, really. One way to take it into account is just to factor it into the new property cost. Adaptations are dealt with as they always were in terms of being recoverable if they're reasonable. And you simply take into account the betterment in the new property cost. So using the exact same new property cost and but-for property costs here, but adding £50,000 for betterment to that new property cost, keeping the same life expectancy, one can see that in effect, you just end up with a slightly larger value for reversionary interest. And that means when one calculates damages for this head of loss, you just get slightly less. And that takes into account betterment. And there's obviously different ways for people to do it. It's not something that is explicitly addressed. But I think that's the most simple way that one could look at it to ensure that you take into account betterment. Nick, I think you're going to now look at potentially the judgment itself.
I am, so I'm just going to bear with me whilst I try and share my screen. Okay, well, hopefully everyone can see that. You should be looking at a side which says, I accept the submission of the intervener. As Lois has just mentioned, I'm going to move on now to talk about a couple of circumstances in which it may well be appropriate to depart from the Swift formula. And the fact that there are such circumstances is advertised in the slide in front of you, which is paragraph 210 of the judgment, where it said that, or rather there is reference therein to longer lives and negative or low positive discount rates. I think it's probably worth beginning by some discussion as to the status of Swift. Now, you will all know that one of the issues which the Court of Appeal had to grapple with is whether or not it was bound by the decision in Roberts and Johnston. And it matters little, but that issue was subdivided into three questions. And one of the major preoccupations of the issue was whether the Court of Appeal was prevented from revisiting Roberts and Johnston. Now, necessarily, you will all know that the Court of Appeal found that it wasn't bound by Roberts and Johnston and that it could and should revisit it. Now, the court's essential reasoning for so concluding was this. It was said that Roberts and Johnston did not amount to an enunciation of a legal principle, which of course would have been binding, but actually it amounted to no more than guidance as to how, in the circumstances prevailing at that time, to achieve compliance with a legal principle. And the legal principle in question is that a claimant is entitled to fair and reasonable compensation but not overcompensation. In other words, as famously said by Lady Hale in another case, the claimant's entitled to full compensation, not a penny more, but not a penny less. So the point of all of that is that Roberts and Johnston wasn't the end, it was the means by which the end was achieved. And the Swift methodology is precisely the same, which is why you can see at paragraph 210 that it's described as guidance. So there's no question that it can be departed from theoretically, but that is not to say that it will be easily departed from. Now, one of the reasons why it will not be easily departed from is, of course, that one of the endeavours of Swift was to provide certainty and consistency in the calculation of damages in this area. And that's thought to be, or was thought to be by the Court of Appeal in Swift, to be of particular importance in personal injury cases. Lord Justice Irwin said at paragraph 78 of the judgment, which is not in the slide, so I'll read it. Perhaps more than in any other field of litigation, disputes are resolved by negotiation and settlement. There is the strongest possible need for clear guidance from the courts as to how fairly to approach such negotiations. Both claimants and insurers have a strong interest in predictability, which brings resolution and some containment of costs. And that sentiment was echoed by Lady Justice Nicola Davies at paragraph 215, again not on the slide, so I'll read the relevant portion of it. There is a real need for effective guidance by the courts in this area of personal injury law. As all who practice in this field are aware, many cases never reach trial. Negotiations leading to the narrowing of claims and settlement are an integral part of such litigation. What is required is clear and workable guidance by the court, which should enable practitioners to provide legally sound and practical advice. So what is made abundantly clear by various passages in the judgment is that whilst it is guidance that must be applied, save for perhaps in certain circumstances which are identified in the judgment. That is why on the slide in paragraph 210, you'll see the guidance being described as enduring, which of course followed previous statements to the same effect. And the point is probably most forcefully made by Lord Justice Underhill at paragraph 222, again not on the slide, but I'll read it, when he said this: guidance of this character should only be revisited in response to really significant changes. And in the case of appellate guidance, which it generally is, it will rarely, if ever, be right for that guidance to be departed from by a first instance court. So, not to be departed from lightly, but can be, which of course begs the question, well, what then are the circumstances in which it might be permissible to depart from the methodology? Now,
Nicholas, could you take us to the slide that you're on? Sorry.
I'm on now.
We're on the short life expectancy, so I think we might need to go into presentation mode.
I beg your pardon.
Sorry. Those quotes that Nicholas has just read anyway weren't on the slide, so you haven't missed anything.
If you want me to share mine, Nick, let me know. And I can...
so share mine. Let's go to, I beg your pardon, everyone. Let's go to the slide beginning major economic change.
Okay.
Well, actually, we'll go back to the slide before.
Yeah. Okay, bear with me. So you should now be able to see on my screen, Nick, paragraph 210. Is that the one you're wanting?
That is the one, and that's the one to which I was referring. So I'm very, very sorry if people were less able to follow what I was saying because they didn't have sight of that slide. And at the risk now of sounding like Chris Whitty, next slide, please. Okay, thank you. Right, now the first circumstance in which it will be permissible to depart from the SWIFT methodology is where there is major economic change. Now, the Court of Appeal, having decided that it could revisit the Roberts and Johnson formula, of course, then went on to consider whether it should revisit it. And as you well know, that question was answered in the affirmative. And in broad terms, the reason for the court concluding that it should revisit Roberts and Johnson, as I'm sure you're all aware, is that it was considered to be unfit for purpose in the prevailing economic circumstances, because of course it produced a nil award for a real and immediate loss. So it seems to me that it's wholly uncontroversial that the SWIFT approach may not or will not survive significant change in economic circumstances and a return to positive discount rates. What's more controversial is what will happen when that situation eventuates. So what will happen when discount rates return to higher than what's described in the judgment as low positive? Query what precisely is meant by low positive. Now, obviously I'm not a soothsayer, but within the judgment, there's certainly support for the proposition that things will revert to Roberts and Johnson. Now, some of you may think, well, that can't be right, because throughout the currency of that formula's lifetime, it was criticised for all sorts of reasons. That's a point which Lois has already made. Those reasons including the fact that it created hardship because it required a claimant to fund the accommodation shortfall from his own funds or by scavenging from other heads of loss. And because it led to anomalous cases, the most obvious of which is short life expectancy cases that produced, under the Roberts and Johnson formula, only ever very modest awards. But notwithstanding all of that, it's important to remember, in my view, that the reasons given for revisiting Roberts and Johnson was the result that that formula produced in the era of negative discount rates. It wasn't the sorts of criticisms that were circulating for decades about the formula and the results that it sometimes produced. And again, this isn't on the slide, but that point is made abundantly clear by Lord Justice Underhill at paragraph 220 of the judgment, where he said this: "I do not believe that the approach taken in Roberts and Johnson produces fair compensation in the circumstances of this case. That approach may have been vulnerable to criticism from the start, and criticisms have been made for many years." Skipping forward slightly, "It may be, though I'm not sure, that those initial criticisms could have been answered by saying that no general approach can produce perfect justice in every case, that it was practical if imperfect." Skipping forward, "But I do not think that that is such an answer as sustainable in the circumstances now prevailing." So in my view, therein lies support for the proposition that, at least in the mind of Underhill, Lord Justice Underhill, that in the event of major economic change or the rising of the discount rate, we may well revert to the Roberts and Johnson formula. Now, next slide, please. Now, the second obvious, and it's obvious from the judgment itself, circumstance in which it may be permissible to depart from the SWIFT methodology is the case of short life expectancy. And we have on this slide, paragraph 171, Lord Justice Irwin, where he said this. He said, "It is instructive to look briefly at the rather different impact of these valuations in paradigm case 3. Now, just pausing there, I'm sure most of you know this, but in case you don't, there were various paradigm or hypothetical cases, which are in fact next to the judgment, which were used by the court as an aid to discussion, so as to see what the outcome of various approaches to calculation of damages in those cases would be. Now, it goes on, involving a much shorter life expectancy. It is not surprising that in such a case, the reversionary interest is much greater, whichever discount rate is adopted. In such a case, the economist's evidence would also suggest that there is a greater risk of the asset being realised perforce during a downturn in property prices. Next slide, please. However, normally the risk of investment in such a case would appear to be lower because of the much earlier return. This illustration is not close to the facts of the incident appeal. As I have noted above, we know from the government actuary that the average span of a personal injury claim is around 43 years of future life, and so paradigm 3 represents a case far from the average. It may be that different considerations and arguments could be applied to that category of case. I make no further comment on that and should not be understood to express a view on it. We can add also to that, which isn't on any of the slides, what Lord Justice Underhill said at paragraph 228. He said this: having said all that, I must emphasize that I am concerned only with a case of the present kind, where the claimant has a long life expectancy. Skipping forward. The position will be different in short life expectancy cases. Skipping forward. These may require a different approach. So, notwithstanding the fact that those are fairly tepid words, that they're tepid in the sense that it's not definitively said that short life expectancy cases do and will require a different approach, only that they may. And they're tepid to the extent that the Court of Appeal avoided explicitly grappling with the problem case of short life expectancy cases by seeking refuge in statistics. What they're saying essentially is, look, this methodology is going to work in most cases, so there we are. But what there is in those tepid words is unequivocally a recognition that short life expectancy cases present a problem. And the problem should be obvious to all of you. It is this: the shorter the life expectancy, the more valuable the reversionary interest is, and therefore the greater the shortfall will be between what the claimant needs and what the claimant is avoided. Next slide. Thank you, Lois, you preempted me. Okay, and that is illustrated by the slide we've got here, where Lois has helpfully done one of her worked examples, and it's a case which involves a 10-year life expectancy and a shortfall between the but-for property costs and the new property costs of £500,000. And the Swift formula produces there a value for the reversionary interest of about £300,000, and that of course represents the shortfall between what's required and what it will be awarded. So you have a shortfall of about 60% of the increased capital sum required. Now, next slide, please. Now, again, it's pretty self-evident that that produces, or that formula and that particular set of circumstances produces a pretty significant shortfall. And it perhaps need not be said that why it's particularly problematic in the case of short life expectancy is because there are typically fewer other heads of loss from which to take the money to make up that shortfall. Next slide, please. Now, how to deal with that? anomaly or difficulty is obviously a question which needs to be addressed, but it seems to me fairly obvious that there's a question which needs to be addressed before we look at the possible solutions. And that question is this: what counts for these purposes as a short life expectancy? And the best answer I've heard to that is as follows. I should say that I owe the following analysis to a much more distinguished legal mind than mine. But the analysis is essentially this. It's important not to fixate on the figure, the number of years, and actually the fixation should be directed towards the result that the formula produces. Now, fixation on the number of years, so it is 4 years, 5 years, 6, 7, 10, and expecting some sort of numerical line to be drawn in the sand is obviously problematic, because many of you might think that it's intuitively wrong and certainly entirely arbitrary to think that someone with a 9.75 year life expectancy is a short life expectancy case, whereas someone with a 10.25 year life expectancy is not a short life expectancy case. Now, it's clear from the judgment, or tolerably clear at least, that what the Court of Appeal was particularly troubled by in the case of short life expectancy was the size of the shortfall that their method produced. In other words, the difference between what a claimant needs and what a claimant is awarded. And that point is made by Lord Justice Underhill in paragraph 228, which we've touched upon in part already, isn't on the slide. But he says there, insofar as is material, talking in the case of long life expectancy, in such a case, the application of a discount rate of 5% will mean that the shortfall between the cost of the additional element and the amount awarded will typically be comparatively small. And this is the important bit: the gap between the need and the damages following deduction of the present value of the reversionary interest should be capable of being bridged without creating substantial difficulties for the claimant. Now, the point of all of that, and the reason why it might be said that SWIFT quite obviously shouldn't apply where there's a significant shortfall, is because if the methodology produces a shortfall which is too big, then the formula is not achieving what it's designed to achieve, namely the preservation of the principle that a claimant gets full and reasonable compensation. Now, it probably follows from all of that that the bigger the shortfall that is produced and the more difficult it is for the claimant to make up that shortfall, the more likely that SWIFT will not apply. Or to put it another way, the more likely that a court might be receptive to the argument that SWIFT should not apply. Now, that will involve consideration not just of the figure in question. So like the number of years, it's not just a question of thinking, look, it's £300,000, that's substantial, therefore SWIFT shouldn't apply. What needs to be done is the setting of that particular figure in the wider context of the claim. Because, for instance, a £300,000 shortfall in a £10 million claim represents only 3% of the damages, whereas £300,000 shortfall in a £1 million claim represents about a third of the total damages awarded. And so in that latter scenario, although the amount of the shortfall is the same, the shortfall and the effect of it is much more likely to be significant and have an adverse effect on the claimant. For instance, it may result in the claimant just not being able to buy the accommodation that the court has determined he or she reasonably needs, which is, of course, an affront to the very principle that the Court of Appeal is trying to protect by this sort of methodology: full and reasonable compensation. Now, what then are the possible solutions to the conundrum presented by short life expectancy cases? Well, bullet point 1 on the slide in front of you, axiomatically it can't be Robertson Johnson. It doesn't work with negative discount rates. For those of you who've read the judgment, you'll probably have seen that in the case of Swift, at least at first instance, one of the alternative methods of calculating this loss that was advanced was maintaining the Robertson Johnson formula, but substituting for the negative discount rate some other rate of return. And actually, I think what was advanced on the court was the rate of return at the very beginning of the life of Robertson Johnson, which was the same as the interest that attaches to general damages. That wasn't something that was pursued in the Court of Appeal, so far as I understand it, not least because there doesn't seem to really be any justification for it. The second solution, bullet point 2 on your slide, is the award of the full capital value. Now, I confess that when I first heard that this was being advanced as a possible solution to the problem created by short life expectancy cases, my initial reaction was, well, that's manifestly completely wrong. And that is because that leads to overcompensation. Now, that is not only an outcome which is contrary to first principles, but it's also the outcome that Robertson Johnson and indeed Swift have gone to extensive lengths to try and avoid. But on reflection, I'm not sure that I was right to be so dismissive of that, because if you read the judgment in Swift, that is very much the direction of its travel. Now, don't forget that although various methodologies were at the beginning of the appeal proposed, they were all abandoned as essentially unworkable. Things like interest-only mortgages backed by a PPO and so on. So the choice for the Court of Appeal in Swift was between awarding the full capital sum or that sum discounted by the value of its notional reversionary interest. And it's worth saying that a number of the methodologies that were other methodologies that were abandoned for reasons that are probably going to apply in just about or almost certainly every case. Interest-only mortgages not being available if they're backed by a PPO, insurers not having the corporate structure and regulation to take charges over properties, or indeed the court lacking jurisdiction to so order. Now, the judgment in Swift is replete with references to the award of the full capital sum if there is no workable alternative available. You can see that from paragraph 149. Again, I'm sorry, it's not on a slide, but what's said therein is this, and this is again Lord Justice Irwin. The second question is whether the appellant's argument that there should be no reduction to reflect the windfall should be rejected. My answer to that will depend on whether a valid and reasonably workable approach can be reached to establishing the current value of such a windfall. And he went on at paragraph 206 to say, if it were to prove impossible here to award a claimant full compensation without a degree of overcompensation, then it seems to me likely that the principle of fair and reasonable compensation for injury would be thought to take precedence. So, of course, what it's taking precedence over there is the principle of avoiding overcompensation. So it's being said that it's better to overcompensate the claimant than to undercompensate the claimant. So it seems to me that self-evidently there is within the judgment support for the full capital value being claimed and indeed awarded if the methodology in SWIFT doesn't produce compensation which is adequate. Now, the final solution or issue or discussion on this slide is rent, claim for rent. And I'm sorry, I'm getting slightly conscious of time, so I'll rattle through this. Historically and typically, renting is not attractive or hasn't been attractive to claimants for the reasons that Lois, or some of the reasons as identified by Lois on the slide, difficulties with adaptations and problems with security of tenure. But I think in cases where there is a manifest short life expectancy, perhaps if you're talking about single digits, notwithstanding the fact that I told you not to fixate earlier on the number of years, it might really be something for defendants to think about. Because if the increased capital cost of the property is £1 million, but it's only going to cost £100,000 to rent that property for 5 years, there's got to be a pretty cogent argument, hasn't there, for the latter being the preferred course. And there are ways, I think, that the defendants could make that course more attractive by, for instance, including or adding in a contingency for more than one move, or perhaps allowing more square footage than would ordinarily be required. Now, next and last slide, please. This is the final discussion point, which I'm going to deal with extremely briefly because of the time. And it's about residential care in later life. And the question is, well, how will the SWIFT approach work in a case where the claimant is to go into full-time residential care before the exhaustion of the life expectancy? So you know that the accommodation is not going to be required for life, which is, of course, the basis for the calculation. I think the solution to that is probably to artificially shorten the life expectancy so that it coincides with the date upon which the claimant is expected to go into care. I think prima facie that's a pretty attractive approach, though I caution that doing that might run the risk of converting a long life expectancy case into a short life expectancy case, such that the SWIFT methodology doesn't produce fair and reasonable compensation. Now, some of you may be relieved to hear that I'm going to hand back to Lois now, who's going to deal with one final issue, I think the issue of child claimants.
Yeah, thank you. I'm going to deal with child claimants, again, being conscious of the time, and also there's so many permutations for child claimants. I can't deal with all of the scenarios that seem to be arising. And indeed, we've all been watching seminars on SWIFT versus Carpenter. We've all been looking at the different scenarios, and this one seems to come up time and time again. I think it's particularly at the forefront of people's minds at the moment. There was a scenario in the judgment of SWIFT and Carpenter that set out a child claimant. But I think the first thing we need to consider is life with parents first, and how one takes into account the but-for properties. And I'm just going to go, of course, to a worked example, because that's the best way, I think, to see it through. And one of the things that Nick said is not to focus on the years or anything, but to look at the practical implications. And the best way to do that, I think, with child claimants is to work through the various ways that you could do it and see what the difference is. The scenario here is very unlikely, but let's go with it. So the claimant's 5 at the date of trial. Let's take a brain injury case, for example. A life expectancy to 45, say 40 years, would have lived at home for another 20 years, and so until they're 25, and then purchased a property worth 400,000 at the age of 25. So £200,000 put in by the claimant, at £200,000 by his partner. and now needs a property worth £1 million. And in effect, the question is, well, how do we deal with that? And how do we also deal, coming on slightly later, to if they would have purchased 2 properties? Now, the first one is assume the capital injections now. And this is a scenario, I think the most straightforward one. It's one that I've seen raised several times. So we're using the exact same formula. We're doing 1.05 to the power of minus 40 for the life expectancy. We're timesing it by the difference of the property before and the property after. And we're getting that figure for reversionary interest of 113,000. 800,000 minus that gives you a figure of about 686,000. And obviously there we're making the assumption that you'd have the £200,000 right away, which isn't realistic. The second one, and I only put it here to show really why it would never work. There's 2 calculations that you do for reversionary interest. You effectively take the first 20 years when he wouldn't have had any but-for property and work out the reversionary interest. So 1.05 to the power of minus 20 for the first 20 years of that life expectancy, times by 1 million gives you that figure for reversionary interest. And then you do a second calculation, in effect, for when he would have had £200,000 for the but-for property. And that gives you a figure. And the problem with that is you're double counting the reversionary interest. So one can see below that you're saying, okay, well, 800,000 is the difference, but take away this and take away that. And it just doesn't work. And I've seen people look at this calculation, and I can make no sense of why you would ever do that, because you're double counting. It seems, and again from commentary and seminars, that everyone seems to be agreed that some form of weighted average is probably the best way to deal with this. And we'll go back to example 1 and the figure we got, and also this one. So here we're looking at 1.05, taking the same life expectancy. But what you're effectively saying is, okay, well, I'll weight the average. So for 20 years, his but-for property is 0. And for 20 years, his but-for property is £200,000. And you'll now see why I've used this very easy example of the same time difference between them. And there, when you're looking at it, you take the £200,000 and you divide it by 2 to account for that. And that gives you a figure of £127,841 for reversionary interest. Do your damages at the bottom, and you'll see that you end up with a figure of £672,158. Very specific figures here, unfortunately. And if one goes back, you can see number 1 of injection now is 686,000. And looking at the weighted average, it's 672. So there's not gulfs between them. But going back to what Nick says, if you have one of these cases and you're considering how to get a just and equitable award, clearly number 2 doesn't work. And conversely, if you run 2 property calculations, so 2 lots of 800,000, that won't work either. But you can work through these scenarios, and I think that's where you see that a weighted average may be the way forward. And or the first example, there's no huge difference. There's no right answer at the moment. It's not something that anyone really has a definitive view on. The only other thing that I'm briefly going to cover, because I'm very conscious of the time, is 2 properties. So this is exactly the same scenario that I've just dealt with. He purchased a property worth 400,000 at the age of 25, but then he would move to a new property worth 800,000 at age 35. How do you calculate that, and how do you take it into account? Well, the first thing is, I think you need to look at when the property is purchased. And again, I think the answer has to be weighted average. And if we go back to number 2 here, do 2 calculations for reversionary interest. One way to do it would be to do those 2 calculations, taking into account the different properties, and then find an average between those 2 figures. So between the 376 here and the 301. Again, it has to be some form of weighted average, I think, to take it into account. And it goes without saying that if he's only going to buy a house at age 44 that's worth £800,000 with a life expectancy of 45, and that becomes a rather futile calculation, and it may be that you just take a pragmatic approach. I premise all of this by saying there's no right answer at the moment. I have watched various seminars and read articles where people are approaching this differently. But child claimants, I think, really tend to be the one that everybody seems to keep coming back to. And so I think my preference in this would be a weighted average. So you're looking at it properly, you work through those scenarios, and you come to a figure that is acceptable for everyone, doesn't represent a windfall or undercompensation, it seems to me. And again, I just make the point here that consistency is key here. If you're saying the claimant would have been a city law firm solicitor earning, you know, X amount a year, then your schedule has to be consistent in that regard. And simply saying, oh, well, he would have bought one property, £200,000 over and out, it is probably unrealistic. And so a lot of it's going to flow from the earnings that would have been earned, but for the accident. So my view on that, as I say, is probably some form of weighted average, and that seems to have some support generally. I think that's everything. I've rattled through that fairly quickly. If there are any questions at all, there was one question that had been submitted before. Perhaps it's best I deal with that briefly now. Nick, I think that might be the most sensible way to just deal with that one quickly, and then we can see if there's anything else. Is that okay?
Yeah, of course.
The question, accommodation based, but not Robertson Johnson or Swift and Carpenter, as far as I can see, was about, and apologies, I'm reading it. What are your thoughts on children who have, for example, suffered a brain injury, whose parents have separated and the child spends equal time with both parents? The way I've taken this is just a general question, probably about adaptations and things, rather than under a Swift calculation. In terms of that, it's that flaky lawyer answer that everyone hates, which is, well, it depends. But I think it really does depend in this circumstance. It depends on a few things. There's certainly an argument for the two properties and two awards. But I think it's going to depend on the facts of the case. So if you've got mum up in Scotland and dad in Birmingham, for example, then you can see that simply saying, well, no, you know, you have one property that's fully adapted for the therapies, for absolutely everything, is just not a realistic way. And you've got to go back to what's always at the forefront. The claimant is entitled to be back in the position they would have been had the accident not occurred. So they spend 50% of the time with mum and 50% with dad. Then your starting point is, well, that's what they're entitled to do. That being said, one has to look at how practical that is. Because if this is a claimant who is having therapy every day, we've got various physiotherapy, hydrotherapy, it's simply a question then of how realistic and pragmatic that is. If you have parents that are based very, very close together, then there may be an argument, for example, for one house to be fully adapted and the other house, and that to be for your therapies and your sensory, and the other house to be adapted for the bedroom and bathroom, for example. So you've got one house that can service all of those therapy needs and one house that can't. And again, the reason I say that it's fact specific is if one has parents that are some distance away, that becomes less attractive because you're then having to move the claimant around and they're having to have therapy at one dedicated house. So the answer in short is I think there's an argument either way. There's an argument, well, we're entitled to be put back in the position we would have been in, 50% at each parent's house. That can practically work, and we can show you it can work with this. But also taking into account how it'll actually play out. If you've got a very complicated and complex care regime in place, if you've got therapy needs that are substantial, how is it actually going to play out? And it always comes back to what is reasonable and what is pragmatic. And I think that's the way I play it. So apologies for the rather flaky answer, but don't know the scenario exactly. Be more happy to give more specific guidance. I think that's everything really on that. I don't know whether there's any other questions. I can't see anything other than my screen now. So
don't think we've had any other questions come in yet. So
well, as Nick said, both of our emails are at the bottom of this slide now, hopefully. Very original, nf@no5.com and ellen@no5.com. If there are any specific questions or follow up or chat about working examples, then feel free to contact either of us. But otherwise, hopefully, that has been a bit of a run through.
That's wonderful. Thank you both. It's really interesting to go through the worked examples and to hear your thoughts, and also to be reminded of some of the key quotes that have come out of this case, for us to kind of have in the background whilst we're kind of thinking about the different scenarios. So it's really, really helpful. Thank you so much. And it's lovely to have you both here today from your respective kind of home cities, whilst we're here in Bristol. So thank you. As I said, we've had a lot of people say would love to come to this, would really like a copy of the slides. So those will be made available. And this recording will be live on the Bristol Law Society website shortly. So just keep an eye out for that in the next few days or so. It might be up in a week, if it's not up shortly. But yes, thank you very much both. Really appreciate
thank
you joining us here today.
Indeed. Thanks so much.
So hope everyone enjoys the rest of their days. Thank you for joining us. And please do take Nicholas and Lois up on their offer of emailing if you have any other questions later on. Thank you.
Hello, I've kicked them all off.
Perfect.
I was wondering if you could do that, Claire. That's great.
Yeah. Normally we suggest that you put your you turn your video off so that everyone sort of decides they're going to go, but it's not a problem. Yeah, no. Oh, there's still somebody there.
Is it Vic? Oh, weird.
No, don't know. Let me just stop this recording.